Hi, so today I shall introduce you to criminal law as far as concerned for the entrances. It is an important chapter and integral part of for both reasoning and knowledge questions. This video covers the two elements and the three primary legislations or the sources. The remaining topics shall be discussed in the videos to come. So here are the much heard terms actus reus and mens rea. To further your understanding of the mathematical equation written here is an example. So prima facie, an executioner's job or an army soldier's job for that matter may seem as a crime as the act is wrong, that is of killing someone, but there is no wrong intention present, thus it doesn't constitute as a crime. Please note the omission example that has been highlighted as this is an important concept and is tested by giving various scenarios of moral omissions and not legal omissions. The moral ones don't give rise to any liability, which is the core concept which is tested. In mens rea, it is important to note that it is not defined anywhere in the IPC, but its essence can be seen in various judgments and contexts. So legislations, these are the various sources for criminal law in India. There are three primary and paramount ones. Do keep in mind the years mentioned. Apart from these offences, there are also acts for specific legislations like the Dowry Protection Act or Prevention of Corruption Act or even the Arms Act, etc. These list offences or provide specific punishment that have not been mentioned in the IPC or correspond to the IPC offences. The IPC. This was enforced in 1862 and was enacted in 1860, which is an important distinction. And so is the Repeal Penal Code here important. Moving on to the CrPC. This is the procedural legislation. It lists a three-stage procedure, explanation of which is for higher studies and not for the entrances. This procedural front supplements and complements the substantial front, which was the IPC, and they go hand in hand. The Evidence Act, the most important point here is the one of the extrajudicial confessions. Moving on to some past year questions for greater conceptual clarity. Please do pause the video and go through the principle and facts. So this is a classic example of the looking out for keywords rule that I mentioned earlier. The keyword here in the facts being totally cornered. So this should reduce your time taken to get to the question by half at least. Now this question is a classic example of sticking to the principle strictly rule, which by word rule. So while we may use negligent, rash and drunk interchangeably in common parlance, but the principle doesn't do so, hence the answer is A. So here, as you may have noted, the more tougher job is to decode the principle or figure out what it tries to say. And once that is done, once it is deciphered, it is super easy. The question becomes super easy. So this can only be done via practicing criminal law questions or reading few IPC sections, which I'll mention in the next video. So this one is a pretty direct question on common intention, and the only variation that has been tested here in other papers is that one may intend to rob the aggrieved party and someone else kills the aggrieved party. So that in that scenario there is no common intention, but here all three intended since the start for murder. Pay attention to the names here as you get confused and sometimes attempt mark wrongly. This would have been attempt if the halwa was planted in Vinay's house and not his house himself. Moving on, the last two questions, they are both based on these two principles and Lord Blackburn's statement, his definition of attempt. For the first question, the answer comes from Lord Blackburn's statement itself from his last line, as we can't say for sure whether the act would have culminated if not interrupted. Rani could have stopped at the edge of the well and changed her mind or whatever the scenario could be, but we can't say for sure. These questions, which have subparts and 2-3 questions linked to the same principles, and where there is more than one principle, they tend to take up time. So do be smart in attempting these questions. So the last question here is rather shorter than the principle in fact, the two principles and the statement. So I would advise that when short on time, or generally also, to glance through the facts first in such cases and then thoroughly read the principle only if required. As in this case, if you will see, you will see that it is clearly mentioned in the fact that there is an intention on the part of Jan. Therefore, the answer is bound to be one of guilty, and there is only one such option present. So the answer has to be A. So in this way, you save a lot of time by not reading the principle in that depth which you would have done if not for such a short fact scenario. So that's it for these parts. The other parts of criminal law will be covered in another video. Thank you so much. Keep posted here.